So what is lawful basis of processing personal data? When we're talking about lawful basis, we're talking in respect to personal data, because GDPR is related to processing of personal data. So it's not processing anything, it's processing personal data. And we have already discussed what is personal data. So this is about processing personal data by a controller, by a processor, by an organization basically. So to comply with GDPR, any organization processing personal data must have a valid legal basis. They should provide it in written that, what is the lawful basis through which we are processing this data and why are we processing this data. And there are several documents that are made on it. For example, you have a data processing agreement, which is compulsory. You have a processing impact assessment document, which is compulsory, so that it gives you details about how the data is processing. But before we go to how the data is being processed and documenting those results, it is very important for us to understand what are these legal bases of processing that we can use while processing data. And once you understand that, only then you will be able to make something for your organization and process data on that basis. There are 6 lawful bases of processing under the GDPR. We'll talk about it one by one, but for now you remember that there are 6, and there is no rule that this is better than other, like one lawful basis is better than another lawful basis. All of them are equally good and equally important, and which is the most appropriate will depend upon the situation and the circumstance in which you are placed as a privacy specialist. You have to see that which lawful basis is most suitable for my organization and my purpose, which is the lawful basis which will not really get me in trouble. So that is something you have to understand, that if I use this tomorrow, one of my customers or clients should not come and say that, no, this is not the right way you used it, and why did you use this legal basis of processing? So keep that in mind, because as a privacy specialist, you are responsible for non-financial risk assessment in an organization, right? Privacy compliance is what we do under GDPR, and doing privacy compliance is equivalent to risk assessment. So here you are doing a non-financial risk assessment in an organization. So that is quite an important job when you are a privacy specialist, and it may fall on you if you don't do it properly. So be very vigilant about the fact that which legal basis of processing you're going to use while processing personal data on behalf of your organization. So most legal basis or most lawful basis require that processing is necessary. We'll also look into what is necessary, so quote unquote necessary for a specific purpose. If you can reasonably achieve the same purpose without processing, you won't have a lawful basis. So see, GDPR is all about protection of rights of individuals, and it also states that if you can achieve something without processing personal data, try to use that. Go and achieve that without processing. Process data only when you can prove that it was necessary to process data so that I can achieve a defined objective by the organization, and that is by processing. So that necessary has to be proved every time you're processing personal data. You must determine your lawful basis before you begin processing, and you must document it. See, as a privacy specialist or as somebody who's looking into privacy compliance or GDPR compliance, remember one thing, as a rule of thumb, you have to document everything. Any compliance personnel must document everything. It should all be in writing, whether it is your mail, whether it is a cloud repository by your company, everything must be documented and stored. Do not do anything just like if there is a verbal agreement and let's do a verbal agreement. Everything, if there is a verbal agreement, put it in paper and keep it for your own safety, because tomorrow if a compliance check happens, you have to show that I have it documented. We discussed this, and as per the discussion, this is. As a rule of thumb, as a practical matter, when you are working as a privacy specialist or a GDPR specialist or a risk manager in privacy, ensure that everything that you do is documented, and you cannot decide the lawful basis after you have done half your process. You're processing personal data for whatever purposes you want, and then suddenly, oh, I did not decide what would be the lawful basis here. I think consent would be best. Or let's use legitimate interest, because for consent, I might have to go back to the customer again and ask for signing. It cannot happen. It doesn't happen like that. Practically, you have it all prepared, and when you're about to process personal data, you inform the customer that, hey, I need your consent form signed here, or I need this form signed here, where you've written a lot of details, your name, customer's name, what is customer's role, who's the controller, who's the processor, process. In this case, why are you having this contract? That would be the body. Why do you plan on processing this data? What is your legal basis of processing data? How do you plan on securing the data? All that must be written. So in that document, you have to specify that which legal basis you're using, right? And when it is about legal basis of processing, once you've specified in that document that this is the legal basis of processing that I plan on using by the organization, you cannot go later and just swap that. Now I think this is not good, so let me swap to another. You'll have to restart the whole process. You cannot swap from one legal basis to another just by your own convenience. When we were reading about processors, that the processors would give a wide range of processors so that they can swap from one processor to another. You cannot do this when it comes to legal basis of processing, that you ask your customer to sign consent also, legitimate basis and contract also, and then you're like, let me get it all signed, and then tomorrow if I have to switch from one to another, I will switch because I have it all signed. It doesn't happen. You have to choose one. You have to stick with one. You have to justify why that one legal basis is necessary. And your privacy notice should include, right, why is this legal? I'm using consent, I'm using legitimate interest, I'm using contractual terms, I'm using vital interest as part of my processing, whichever. It's not and, it's or. Which consent or legitimate interest or vital interest or contract, things like that. Which one you're using and why are you using it? What is the purpose behind processing of data? And how do you prove that this is something that's is the most suitable, is necessary? And also, if your purpose change, you need to consider that whether you need a new lawful basis. And even if you think that the old lawful basis works, you have to inform your customer that, hey, my purpose has changed and this is the new purpose for which we will be processing your data, and you need to really get fresh documents signed because your purpose has changed. You can justify there also that even for the new purpose, the lawful basis is going to be consent, for example. But you have to justify why is consent the most important, or how is consent the most appropriate, and why is it necessary to use consent in that matter? For example, why is there any other means by which you can achieve the same objective without processing personal data? So you have to define that there's no other means and we need to process personal data to achieve that object. So you have to be very specific about these things, because this is the essence of compliance. The first part, right? You decide why are we using this, and on these grounds many cases take this. So you should understand that GDPR is very rights oriented. It is about the rights of the individual, and you not deciding or you fumbling on this legal basis of processing can lead to quite a hefty penalty on the organization. The importance of having a law basis of processing as a privacy specialist, why is it important to you? Like, the first principle requires that you process all personal data lawfully, fairly, and in a transparent manner, because that's what it is written. And if no lawful basis applies to your processing, will be unlawful and in breach of the principle. That is why you must decide what is the lawful basis, and you have to correctly decide. Then individuals also have the right to erase personal data which has been processed unlawfully, and also claim their rights and file a case against you if you're using their data unlawfully. The individual's right to be informed under Article 13 and 14 requires you, means a controller, to provide people with information about their lawful basis for processing. It does. We've been talking about it, that when you give out that form, and the lawful basis for your processing can also affect which rights are available to the individual, right? The right to rectification, or their right to erase personal data, right to restrict processing, right object, all those come into play. It's all interlinked.